now we're ready for questions.
Okay, well, I have a really quick question because I noticed Killer Tracks specifically, and there's a couple of NASA videos that cite Killer Tracks. And normally I tell people that NASA videos are public domain because that's kind of what NASA does. But does that mean that a planetarium can't use the music that goes along with the video in their production, even though NASA video is public domain? Like, that caught my eye.
Yeah, that's a great question. I would be slightly concerned about using the music in that because that license probably extended to NASA or the contractor that put that video together, and it's probably not the case that it extends to the planetarium that's using it. This is one of those situations where the likelihood of it being a major issue is slim, but it could be one. So I hesitate to say don't worry about it, but at the same time, you know, as you say, there's the fact that it was in a NASA video is a good fact for you, but to be absolutely safe, I would want to try to license that music myself from Killer Tracks for the use in my own planetarium. The other thing to note, and this is where it gets tricky, because really what you're asking is, what is the scope of the license that NASA had? It is entirely possible that NASA's license allows them to put it online and allows other people to use it in a planetarium environment, but we don't know. And so somebody at NASA would have to tell us. And that can be very difficult, right? Because we typically don't know who to talk to, and when you ask them, they look at you like you're from Mars. But that's ultimately what we need to know. And so to be absolutely safe, you could get a separate license from Killer Tracks before using that. Since you mentioned NASA,
I actually do know who to talk to, so I'm going to go ask.
Yeah, no, even better. And you know, if you know who to talk to, and they do this regularly, it would be helpful if they could put something on the website that gives people some comfort that everything has been cleared for use, because that I would be more comfortable relying on it in that case. But since you mentioned NASA, I wanted to make one other comment about that, because this comes up a lot as well, not usually with music, but with visuals, is the NASA, so you're right, that NASA stuff is a work of the government, and works of the government are not protected by copyright. It's right there in the statute. One of the problems I've encountered with NASA stuff sometimes is that it looks like it's NASA stuff, and if you look closely, it's actually done by a NASA contractor. And NASA contractors are entitled to own the copyright. Typically, in a good government contract, the government will get an assignment of the contract of the copyright to the government. So there's nothing stopping the government from owning copyrights, but they're not allowed to own them for their own works, if that makes sense. So you have to sort of be a little careful with that. Like, I know a lot of the Jet Propulsion Laboratory stuff, the copyright's actually held in JPL's name, Caltech's name. So back in the day, I don't know how they do it now, but this was going back like 20 years. But just something to be mindful of is making sure that NASA is actually the owner of the copyright.
Great, thanks. And I wanted to go back to the fair use for education. So, like you said, when I'm using background music, that wouldn't count as fair use just because it's just background music. But if you, like you said, if I'm using a specific song, like Alan, if you remember, we used the Sun is a Mass of Incandescent Gas song as actually part of the curriculum.
Mm-hmm.
And that's an easier case. Like you said, it's not you can't predict what judges and people will say, but it's an easier case to make if I'm actually using it as part of the curriculum.
Yeah, I agree with that. It's so, like I said, fair use is a fact-based analysis, and that's what makes it tricky. Like, I'm fond of pointing out that people who complain and say, "Oh, it's very ambiguous." It is, but ambiguity is also flexibility. And so I kind of enjoy doing fair use cases because you get to argue it all sorts of ways, you know, depending on where you want it to come out. But I agree with you. I think that's a helpful fact in the fair use argument.
I'd like to remind everybody to unmute if you want to ask a question. But along with what Jeff was just saying, another example of that is I came across the the Transit of Venus Sousa March, which I assume would be okay to use in an educational program. But my question actually has to do with can you comment on the difference between using music in a recorded planetarium show as distinct from a live planetarium show, an audience participation show, things like that?
Sure. Yeah, so it gets a little tricky. I was trying to think through that this morning, actually. So I think most music licensing folks would tell you that as long as you are combining the music with some visual, you need a sync license. On the other hand, just thinking as a pure sort of copyright purist, you're not, the sync license is an application of the reproduction right, and in your scenario, you're not reproducing it into a soundtrack or a film or something, which is what we usually think of as a sync right. So I'm inclined to say that that's probably all right, but there are strong arguments to be made either way. And it's one of those famous, I'm sure you've heard the joke that lawyers always answer everything with "it depends," and that's probably true here as well. It's sort of, we often have this problem where it's like, well, you could argue it both ways, and it just sort of depends, and what's the enforcement risk and that kind of thing.
So this is actually amazing. It's kind of it is confusing, but you said the sync rights, it might be okay because it's not connected with a soundtrack or something. But is there maybe I'm confusing this, is there like a performance right that needs to be?
Yeah. So you would still, I can't think of a circumstance in a planetarium where you would not need performance. So it's really the other ones that are sort of questionable. That's why in the deck, I put that first and I said, let's get this one out of the way. You always are going to need a performance license. I suspect many of you have them already. And the question then is, well, what other rights do you need to use it? And what are you actually doing with the music? But the performance piece, you probably already have. And like I said, they're easy to get because ASCAP and BMI and CSAC, and they love taking your money. It's a couple of them, I think you can even you do them online. I mean, you give them a credit card and you do it online. So they can be more complicated. I mean, bigger deals, usually they're looking at, percentage of revenue from ticket sales and thinking that's how they come up with the rate and that kind of thing. I think some of them for retail establishments, it's based on square footage, that kind of thing. So the metrics are a little bit different depending on what you're doing with music, but those licenses are very easy to get. You just have to pay for them.
And I know that Kevin didn't have a mic, so I'm going to ask this question for him, but he's asking about derivative works. If you remix something for your soundtrack, what is the implications of that?
That would require a master license to do a remix, and depending on what it is, I can tell you the labels are typically very careful with those licenses because they don't want to upset their artists. So I know I have a friend that worked at a label representing that had a major rock artist a number of years ago who just refused to allow their music to be on compilations because they didn't like the idea of their songs being juxtaposed with somebody else's music, and they thought that had some artistic component to it, who was next to them on the album. So that's a slightly different scenario, but if you're taking something and saying, well, yeah, I want to cut it up and I want to do this with it, that's the sort of thing where I think a label's antenna will go up a little bit and they'd want to know more about the use before granting the license, but it would require a master license. And it would require both, but you'd need to talk to both the publisher and the record label.
But now I'm thinking if it's public domain, then a derivative work, something based on something that's public domain, you wouldn't need a license. I'm thinking like, for example, Beethoven's Moonlight Sonata.
Yep.
If you made a derivative work based on that.
Totally fine.
Okay.
Yep. Yeah, there's actually so I mentioned earlier, I work in broadcasting. There's a news theme that a number of stations used years ago was called Stravinsky, and it was based on a Stravinsky piece that was kind of jazzed up to be like a news theme. But that's why that was possible, it was all public domain work, and the composer just sort of remixed it to create his own rendition of it. That's totally fine.
That could be a whole category of work for people.
Yeah.
I've got another question if you have a moment.
Sure.
So we have ASCAP BMI licenses, but for ease of use, we were talking about using a client like Spotify or Google Play. As long as we have rights to play the song, does it matter which platform we're playing it from?
Technically, you still shouldn't be using Spotify to do it because it's a breach of your contract with Spotify. So that those terms of use that I put up forms the basis of the agreement that you have with Spotify for using their service. They could theoretically terminate your account as a result of, or whatever remedies they have in that agreement, which is probably just termination of your account. I haven't studied it, but they could probably terminate your account for breaching the license. The fact, technically though, you're right, you've got the license to do it and you're just using Spotify as the source. So from a pure copyright perspective, I'm not sure I see an issue with it, but it is a technical violation of the license you have at Spotify or whatever service we're talking about.
Gotcha. Thank you.
Sure.
And then I had a quick question about the first sale
Yep.
that you mentioned. So like, let's say that we inherit music on a CD from some other planetarium or from some other person. And in that case, it's still performant. We still need the performance rights, but we have the music and we can use it as long as we have the performance rights.
Yeah, so there's a slight, it depends what you're doing with the music. So performance would allow you to perform it, so you could play it off those CDs. You would still possibly need other licenses, like a sync license, to put it onto into soundtracks. There is a distinction between what first sale really says is there's a distinction between the copyright work and the physical manifestation of that work. So when we talk about inheriting something, you have inherited the physical manifestation of the copyrighted work. Sometimes, like in a music library case, the rights to use that music go with the physical object, but more often than not, they don't. Like if I bought, to go back to the Taylor Swift example I used earlier, I buy a Taylor Swift album at Target, that gives me the right to listen to the Taylor Swift album. That's it. The fact if I die and somebody gets that Taylor Swift album in a box of all my albums, they have the right to listen to it. But they don't have the right to do anything with that music because they never had that right in the first place. So the mere physical possession of the music doesn't give you the rights to use it other than for personal use.
Great, thanks. This has been really, really enlightening and helpful. So thank you for this.
Sure, of course.
Question, or no? Hi, everyone.
Hi, Sharon.
Sorry, I was late. One thing that may help other planetarians with images, sorry, I'm getting off music and the images, is and on Google, when you do an image search, I searched for NASA moon, got tons of images. And it's not always clear if those are NASA images. They could be copywritten by someone else. There's a really cool feature on the Google search under tools. If you're looking at images, go to the right under tools. You can see what use rights are available for those images. You can filter them for label for non-commercial reuse and get images. There's one from JPL that came up. So you can get an idea of the image use rights through Google. That doesn't give you all of the rights to use them, okay? But you can get an idea of whether or not that image is okay to use and investigate further. If it's been copywritten by someone else, it's not going to appear under labeled for non-commercial reuse. Just a note.
Yeah, that's a relatively recent development on Google that we've been thrilled about because for a long time, I used to do a lot of work with photographers, and I am a photographer myself, and we used to be extremely frustrated with Google image search because they would display in the search results full res images from our websites, from photographers' websites. Yeah. And with no indication of where they came from and no indication that they were protected by copyright. So it's been quite a fight by the visual arts associations, the American Society of Media Photographers and others, to get Google to do that. And it's, it's a Herculean effort for Google as well. So but I can't think of a company better suited to the task, but they've done a great job of implementing that. And I agree with you, it's super helpful. To be absolutely certain though, you always want to kind of research that image and make sure it did
Right.
actually come from NASA, because as I was saying at the end there, I've seen situations where people have basically uploaded images with false metadata, either sometimes unintentionally, sometimes nefariously, and that can, lead Google and the best image researcher astray. So to be absolutely safe, might dig a little bit deeper, but I agree with you. The Google stuff has been super helpful.
I had a case where it saved me. I had an image submitted with a column that I was trying to track down the use rights for. No, the submitters don't always get those for me. I do due diligence and search. And the image was supposedly from a Flickr site, but the original image was copywritten.
Yeah.
And I did not use it as much as I wanted to. I did not use that image. So
Yeah.
it's some trouble.
We have another question from Kevin in the chat, and I'll read that off. But I just want to mention first that you mentioned that there's a IPS on the IPS website, International Planetarium Society. There's a area where there's free music, and I just wanted to elaborate for a second on that. I started that. I approached musicians to ask if they wanted to kind of feature works on the website for free, or we could link to their site where they have free works available for use in planetariums. And so a number of composers have put their works up there, or links to their works that are for use. It's under free media, the free media section. Kevin Healy also asked the second question. I'm curious what goes into licensing for redistribution.
Yeah, so the main issue there is, I kind of touched upon it briefly. There's this concept of a mechanical right, which, believe it or not, it goes back to the days of piano rolls, where you had a mechanical reproduction of a piece of music on a tube, a wax cylinder. So that nomenclature still exists. And so if you make copies of recordings or of musical works, you need to have a mechanical license fee paid for each copy that you make. So in a show distribution context, you're making if you sell 20 copies of the show or license 20 copies of the show, you've got to pay that mechanical royalty to the publisher. In addition to that, the scope of the master license that you need would be broader, because when you license for master use, they're going to ask you, well, what are you going to do with it? How big's the audience going to be? How long are you going to use it? Those sorts of things. Those answers are different if you plan to distribute the show to somebody else. And so you would need to take that all into account. So it's the same. You would need the mechanical license, but then on the master side, you still need it, but you would just change kind of the terms and what you need. And it's the kind of thing where, you might do an in-house show and then you go back to them and you say, okay, our plans have changed. We're going to distribute this. What else do we need to do this here? For library music, my hunch is that it's probably in the same, you could license that directly from the music libraries, and I think it might be a slightly different use category, so it might be a second license, but it wouldn't be too onerous. And it's the sort of thing that's contemplated by their license structures, so it wouldn't be a big deal. It's just that you need to do it a little bit differently.
So I've got an anecdote and a question. I don't know if it would apply to planetariums, but a friend of mine and I had this idea of showing a movie in our neighborhood park for the neighborhood. So I went in it blind, and so I had to get a permit from our local Parks and Rec department, and that permit was dependent on getting a license to show the movie from this third-party organization. I think it was called Swank in St. Louis, and I was surprised. I didn't have to purchase the movie, I just had to purchase the rights, and they were fine with us showing a home video copy of the movie as long as we purchased the rights. So I don't know if that would apply to planetariums, probably rarely, but yeah, somebody might want to show a movie there. The other thing is related to Alan's mention of the music available on the IPS site. I've got a friend who's a musician, and he gave me permission to just play his music. You know, he sold CDs back in the day, and now he sells his music on CD Baby online. I don't think there's any quote unquote rights, you know, associated with them, Creative Commons or otherwise. So I've just kind of, you know, I buy his music from him, and then he says it's fine to do it. Is that something I should do more formally with him? Get something on paper? And I'm thinking of approaching him so he could share his music on IPS site if that's something he's enthusiastic about, which I think he might be.
Yeah, I mean, so basically him giving you permission is a license. There's no rule that requires licenses be written down unless they're exclusive. So transfers of copyright, so if I'm selling you my copyright, I have to put that in writing by law. And if I'm giving you an exclusive license to do something, I have to put that in writing. But otherwise, you can just, you know, I could grant you permission to do something and you do it and everything's fine. There is, however, an old adage in the law that oral contracts aren't worth the paper they're printed on. And so if you ever got into a situation where there was a challenge to that license, I mean, it sounds like you know the guy pretty well, and it's pretty unlikely that that's going to happen. You know, the risk-averse lawyer in me says, yes, you should have it written down. But the reality is it's probably fine if you know, work well with him and trust him and that sort of thing. But don't be scared off by the idea of putting it in writing either. I mean, it can literally be just a little note, a letter, you know, like
right.
Here, do this, and I agree to do that, or whatever. It doesn't need to be fancy. There are no magic words.
Well, and the other thing is, most of the stuff he puts out now is original, but he has put out music that has been covers and original work. And, you know, I'm careful only to play the original work because I assume he hasn't gone through the trouble of getting permission to do covers of the work.
Yeah, that's probably a safe, unless you get confirmation otherwise. I think your approach of only using original stuff is the safe course.
So, Alan, is there a standard that this music on IPS site goes through to be available?
I usually ask a composer if they're interested. They usually want to do it in exchange for a link to their website.
Okay.
And so I don't know if that constitutes an agreement or not, but they say that any planetarium, I mean, it's usually done by email. So there exists an email. I don't know if I can find the email, but there exists an email that says that this is fine for any planetarium to use as long as you put a link to my site and give me credit for it. We also specify a credit line.
Right.
That who's it by.
And like with Geodesium, I think he wants you to buy his CD and then you're okay, right?
Yeah.
I think that's probably what his approach would be too. So I'll talk to him and then maybe put the two of you in touch.
Okay. Any last questions?
Thank you. It's been really informative.
Sure.
And in fact, let's unmute. Everybody unmute again. I think this really is worthy of a round of applause. This has been a great,
thank you.
Great session. Thank you.
For the opportunity. Appreciate it.
Learned a lot. Yeah.
Great to hear.
Okay, and y'all have
Chris.
nice.
No problem.
I miss you, Chris.
I'll have to chat about writing again sometime.
Okay.
I'll shoot you an email.
Oh, actually, I do have one last question. It has to do with is anybody, sort of a show of hands or comments, is anybody interested in having another session by Chris that's more focused on visuals?
Sure. Yeah.
Yeah, okay. I see a bunch of hands. You got that, Chris?
Yep. I'll see
I
what
may
I
be
can
coming at you again.
do. Happy to do it.
Okay, thank you so much.
All right. Thank you. You all have a good weekend.
Yeah.
Everybody.
Bye-bye.
Thank you.
Thanks, everybody.